Suzanne Levy has been involved in the gender critical movement since 2019, first as a supporter of standing up for women and later as spokeswoman and leader, dedicating time and energy for a movement she believes in passionately and wholeheartedly. Suzanne says, I was attracted to the SUFW organisation because of their logical, reasonable approach and their feminist principles. As a child of the 70s, I've benefited from the rights that the women before us bravely fought for, and I am proud to be holding the line now. Please, Suzanne.
Thank you, Janet, and hello, everybody. I'm speaking tonight about a submission that Speak Up for Women put in September to the Law Commission, who are reviewing our Human Rights Act and whether or not it's suitable, offers suitable protection for transgender, non-binary people. So I'll start sharing my screen now. Right, hopefully everyone can see that. So in when was it? June this year, the Law Commission, who are an organisation in New Zealand who are responsible for making recommendations to Parliament on various legal issues. Parliament don't have to actually run with what they come up with, but they obviously do listen. In this case, an ex-minister, Kerry Allen, asked them to do a consultation on the Human Rights Act, and particularly to review the protections in the Human Rights Act for people who are transgender, people who are non-binary, and people with innate variations of sex characteristics. So in the Law Commission invited submissions from everybody. It was an open consultation. In February, they contacted Speak Up for Women and asked us to organise a meeting with them and sort of other like-minded gender critical groups, women's groups, which we did. And it was a fantastic opportunity to sort of work with these other groups and to also sit down with the Law Commission and ask questions, give them feedback, etc., before we actually made our actual submissions. So it was quite a good experience. And they gave us lunch, which was great. So you don't get that very often. And it was nice to be asked as well. So the consultation came out, I think, in June, and it was a 10-week consultation period. The consultation document was kind of ridiculous for your average person. It was about 80 questions, and you had to sort of go to an online form and work through each question one by one. And they all kind of matched back to a particular area of their consultation document, and it was pretty arduous. It was pretty terrible. But as a group, we didn't need to follow that particular way. We were able just to put in a written submission, sort of covering their questions and whatever else we wanted to say, which is what we did. So we wrote a document. Tanya Sturt, who's here tonight, she wrote it along with me. It was a huge piece of work over quite a few weeks. We were really happy with it in the end. We worked through quite a few issues. We didn't know exactly what outcome we were going for when we started, because we sort of asked ourselves questions as we went, and it was a really, really good process, and we're very happy with what we came up with in the end. And I think there's a link to it in the chat at the very top if you're interested. So So to start with, because obviously it's to do with our Human Rights Act, which you won't all be familiar with. Some of you will be, but quite a few of you won't be. So back when we were working out how we were going to respond, we did a few workshops with Speak Up for Women supporters, and we did a little beginner's guide to the Human Rights Act. So I'm not going to go through the whole thing today, but I pulled out some slides that are sort of relevant just to bring people up to speed slightly with the way it works in New Zealand, because it's quite different to Australia. So it's our anti-discrimination law. It's very different, I think, to Australian law, but very similar to the UK Equality Act. They look really similar, particularly in relation to grounds for discrimination and what have you. its aim is to provide better protection of human rights in New Zealand in general accordance with the United Nations covenants and conventions on human rights. So basically, it outlines unlawful discrimination, and it describes what it covers, and then it explains who specifically is protected. So in terms of what it covers, broadly, it covers employment, goods and services, and education. So it's very broad, but at the same time, it doesn't sort of delve into the tiny little bits of everybody's lives. It sort of leaves us alone for the most part. But it does provide very clear guidance on these three main areas. So, for example, provision of goods and services. This is the main part of the Act, and it just basically says that it's unlawful to not provide someone. You know, if it's a publicly offered service, you have to provide it to everybody. And in particularly, you can't refuse somebody who is one of the protected grounds, or who is covered by one of the prohibited grounds of discrimination, I should say. So I'll go into those next. So Section 44 is the goods and services ones. There are similar sections for employment and for education. And you know, they have a bit more to them, but I'm not going to go into all of that. But basically, they say if you're providing a good or service, or you're an employer, or you're an education establishment, then you can't discriminate against people. And you know, there are prohibited grounds of discrimination. And then so one of the most important parts of it, from our point of view, are those prohibited grounds for discrimination, and they're often called protected characteristics as well. So these are the grounds that you're not allowed to discriminate on. So obviously sex is the first one. It doesn't describe them particularly, though it does say with sex it says includes childbirth, pregnancy and childbirth as well, and the rest of them have got sort of descriptions that go along with them, but very short descriptions. Most of them are self-explanatory. And these are the only grounds where it's prohibited for you to discriminate. So it's kind of, it is limited to these 13 particular characteristics. And so they're often referred to as protected characteristics, and some are defined clearly in the Act. Gender and gender identity has, since 2006, which I'll move on to the next little bit. In 2004, Georgina Beyer, who was our first transgender Member of Parliament, she proposed a Members' Bill to add gender to Section 21 of the Human Rights Act, so it would sit where it's showing in this picture here. And the bill didn't go through, but Parliament sought an opinion from Crown Law as to whether or not, you know, gender was already included in the Human Rights Act, and the opinion concluded that it actually was already provided under the characteristics of sex. But this was back in 2006, where things were interpreted quite differently. Gender identity wasn't such a thing, and the logic was kind of that if somebody was discriminated against because they were transgender, it was kind of on the basis of their sex. So it was that they weren't, they basically didn't look like people decided was appropriate for their particular sex. So in an employment situation, a male who, for want of a better phrase, looked like a woman was refused a job, not a sex specific job, just any job, because the employer decided that they didn't look like they thought a man should look. So that is sort of a logical way to say that gender is included under sex. So that's kind of where we were in 2006, and unfortunately that's carried on to today, and it's very, very murky, but it is just an opinion, it's not the law. But it's being picked up and run with by various people who think that it's it's great for them. So so Section 21 lists the protected characteristics, and it's obviously a very important part of the Act. but it's not actually the part that protects our single-sex spaces, services and sports. So there are different parts that do that. So as well as the Human Rights Act listing the areas where it's concerned, which is goods and services, education and employment, the majority of the Act actually talks about the exceptions. So these are the situations where it's not unlawful to discriminate. So this is where it gets interesting, and this is where we're kind of concerned. So the most sort of obvious one and the easiest one to look at is actually not this one. These are in the wrong order. But this is still worth looking at. So this one says that, so if you're providing goods and services and you're providing counselling or courses, you're allowed to discriminate, or it's not unlawful to discriminate on the basis of sex, race, ethnic or national origin or sexual orientation, where highly personal matters, etc., are involved. So this means that it's not unlawful for you to say this particular counselling session is just for women or just for lesbians or whatever. So it allows, and the Act is just full of exceptions like this that cover various aspects. And then Section 46 is the one that covers sort of changing rooms and things, which in bathrooms. So this one basically says, you know, that it's not unlawful to discriminate on the basis of sex where public decency or public safety is an issue. So this is a really important one. This is the one that kind of comes into play with changing rooms and bathrooms. And you know, so obviously it's really important, and it's just about sex. So it's no other grounds of discrimination are included. It's just sex. It's the single one of the 13. So, and sport is the other one too that just talks about sex. And you know, and it's pretty logical. It sort of basically just says where stamina, physique, or strength is relevant, you're allowed to discriminate. Now, it's important to note that it doesn't mean you have to discriminate. It just means you're allowed to. So, in theory, if you're a service provider, say, you know, a swimming pool providing or a gym providing changing rooms, the Human Rights Act doesn't say that you must provide changing spaces just for women. It just says you're allowed to if you want to. But having said that, if you didn't provide changing rooms just for women, you could be accused of discriminating against women by not providing somewhere for them to, you know, for them to use so that they could access your service, and therefore making your service inaccessible to women. So it's kind of, it's not quite that straightforward, like a lot of legal things. It's never that simple. So the other section that does a lot of heavy lifting is Section 73, which is called Measures to Ensure Equality, and it's kind of it's what we use to allow a group that might be considered marginalised to hold an event or a class or whatever that's just for them, and they can exclude other people on the basis that they need the space and the event to sort of, I don't know, to help their group, you know, so that they can achieve an equal place with other members of the community. So it's a sort of it's positive discrimination. So it's another really, really important one, and it's probably what if, you know, Sal Grover's Giggle app, it could have argued if your, you know, if sex was defined as it should be in the Act, it would have been this kind of section in I think your Sex Discrimination Act that would have come into play for that Giggle application. So the other thing about Section 73 is it's only available to groups listed in Section 21. So those 13 protected characteristics are really important when it comes to being able to access the special measures. So at the moment, with if transgender people or gender isn't included under sex or isn't included in Section 21, then in theory they are not eligible to hold events that exclude other people, and that's not necessarily a good thing. There would be arguments for saying that transgender people should be able to gather and do stuff for themselves, just in the same way that we want to. Yes, and the only difference is obviously that we're not stopping them. So the way that we sort of approach the consultation is that we welcome the opportunity to influence a change in the Act, because we feel that as it stands, women's rights are not protected clearly enough, and that sex needs to be explicitly separated from all notions of gender identity. And we believe that sex expression can be added in such a way that it does not trump sex, because the protected characteristics in Section 21 are not in competition with one another. They can be referenced completely separately in other parts of the Act, and they are. So this is just a page showing where our submission can be found, and that's also in the chat. So when we looked at this, we sort of, the review itself, we read the document and we thought about what we wanted to say, and we asked ourselves these three questions. Does the Human Rights Act provide adequate protection already for that group? And we decided that it did, but it wasn't clear enough. And then we asked ourselves, should there be exceptions in the Human Rights Act to allow for exclusive access to participation for this group in some instances? So should that group be allowed some separation and ability to act as a group away from other groups? And we think that is fair, but there are obviously issues with defining the group because it's so subjective. And thirdly, can exceptions be added to the Human Rights Act without infringing on the existing ones on the basis of sex? And we believe that they can be if they're managed correctly. So we found that there is adequate protection, but there's so much confusion as well, the way things are at the moment, with gender potentially being included under sex. So, and also it doesn't enable the group, the transgender non-binary, to be subject to any relevant exceptions or positive discrimination, and that it does infringe on current exceptions and positive discrimination measures to ensure equality on the basis of sex. So we did want, our outcome was that we wanted things to change, and then we started to tell the Law Commission how we wanted them to change. So our number one priority was to protect and strengthen the protected characteristics of sex. We wanted to ensure that the exceptions on the basis of sex remained and were clarified where necessary. So the ones that I just showed you about sports, about changing rooms, counselling, etc. So we wanted to make sure that sex remained in there. And our second priority was to see whether there was a way to provide protection for people presenting with differences of sex expression or characteristics. And these are the people that Crown Law said were already protected under sex. So we wanted to find a way of protecting those people, but not under the characteristics of sex, because it's so problematic for the other things we're trying to do. So we proposed two amendments, and the first one was just a really clear biological definition to the ground of sex. And the second one was a new ground to Section 21, so there would be 14 grounds, and it was going to be called variation of sex characteristics, and it's the variation in the external presentation of primary and or secondary sex characteristics. So when we were trying to work out how to look at that protection or that new protected characteristic, we saw that people were in two groups, or we decided they were in two groups. The category one, first category, people with innate variation of sex characteristics and people who've had medical or surgical altered secondary sex characteristics. And category two are people who have a self-professed identity that cannot be defined as subjective and purely ideological. So we see that there's two very different groups of people, and they need to be approached differently. So the first category, who are people who have actually something that they've either done to change their secondary sex characteristics. So they are physically different. They obviously haven't changed sex, but they are physically different. And we decided that that category can be defined in such a way that it meets the threshold for a new prohibited ground for discrimination. And that means that that group of people can have some protection, specific protection under the Human Rights Act. And the one of the biggest things that also helps to create a legal division between this ground and the ground of sex, so that you're no longer saying all genders included in sex, and sex is mentioned in these exceptions, etc., and therefore that includes gender. So it sort of takes it out of those exceptions as well, and it gives us that clarity. And that's just the term, a variation of sex characteristics. That's what we've proposed. So the second category, it just can't really be defined. It's your non-binary man who feels like a woman, that kind of thing. There's too many scenarios and options. There's no way of determining whether someone's even in the group or not in the group. It's impossible to prove any of that. But at the same time, everybody is covered under the Bill of Rights, and there are other prohibited grounds: political opinion, religious belief, all sorts of things. So it's not like people are left completely unprotected. They still have human rights. They just don't have specific ones that name them. Okay, and that's it. So the next sort of thing, we put our submission in September, and the Law Commission are going to be working on this until I think June, July 2025, at which time they'll put in they'll put out a recommendation that we'll all see, and it'll be up to government or Parliament to act or not act on that particular recommendation. And it'll be very interesting to see what does happen. And at the same time, there's a bill in Parliament at the moment called the Human Rights Act Amendment Bill, and it is looking at this as well. So there's a couple of little things that could happen or not happen. I mean, the government could choose just to not do anything with any of this. So that is my presentation. So thank you.
Thank you. Thank you for the clear explanations and explaining your strategy. I really appreciate it.